So first of all, let me introduce Brian Cannell. Brian is with Perform Law out of Houston. And Houston? Aren't you out of Houston? New Orleans, sorry, Houston, New Orleans. New Orleans, yes, he's from New Orleans. He's thinking about going to Houston, but right now he's still in New Orleans. Anyway, I don't know why I thought you were in Houston, but I guess because of Steve, yes. Anyway, so he's a consultant for law firms, and we got him here. Also in the the insurance industry as well. So that's why we thought we'd get him here to provide comment. And why don't you have a seat? And everybody know Howard here, and Gary Bauman is also involved. He's getting a microphone on. And as I said to you earlier today, we're going to use this session to start some discussions on what I think are some very serious and issues that we are facing, and a little bit about our decision process. And really, it's to get some discussion going. There's voting buttons in front of you, and we're going to try to separate the attorneys from the industry. And that's what, so when you see the questions, there's three, in most instances, there's 3 industry answers and 3 attorney answers. So please stay to your, what you do. Although I know many of the people in the industry are also attorneys, that doesn't, you still answer for the industry, okay? Because we want to know about your company and your organization and its decision process, and that's what we're going for. So, and we're going to start off. We have different sections. So Howard's going to start us off, and then Gary's going to start, and then I'm going to start. And we have 3 different sections. Please, this is a safe space. You don't have to worry. Everything's anonymous. The voting's anonymous. But the discussion should stay here. We want this to be a safe space. What comes out of Miami stays in Miami, or what comes out of this discussion stays in Miami. Okay, so that we can be honest in what we say and in our discussions. So and before I start, I want to say a big shout out to Magna. Listen, Magna is not just a sponsor. They're a partner of Themis, and they're a partner with so many of you. Jessica, do you want to stand up? Jessica from Magna. They provide so much support for so many of us. And we all know Peter and Jessica, and they've done so much for us and for Themis. And really, I don't call them a sponsor. I call them a partner. And just really, truthfully, like all of our sponsors, they really are our partners. And I will say, I reached out to Jessica and Peter and said, I saw you do those voting buttons. I want those voting buttons at our annual. And did they deliver? And Victoria back there is working, and we're running her ragged from our changes every 2 minutes. But anyway, Magna's great. Always think about them, and I know you do. But thank you, Magna, for all you do for all of us. Really appreciate it. Thank Magna. Okay. You ready to go, Howard?
I am ready.
Okay. You don't need this.
I'm good.
Okay. So Gary and I are going to be in the audience, and we're here. You can click us and say, I want to say something, I want to ask a question, I want to make a comment. I'll go on the other side. Okay. Howard, all you.
Good morning, everybody. Jessica did ask if you thought that the clicker was a calculator and you put it in your pocket, put it back on the table. They need to take that back with them. I heard a lot of people saying this is a cool calculator. It would have been Themis branded if it was a calculator. So we're going to talk about something very important today. Not the most important thing going on in the country, like Taylor Swift or anything like that, but it is about the relationship between the law firms and the industry. And it's a topic I know that, particularly in the last few years, it's become extraordinarily relevant with all the changes that are going on. And I think for today, what we're trying to do is, I think from the law firm perspective, is really try to be on the same page and learn as much as we can about the perspective from the industry side. And I truly believe more now than ever that we are on the same page, we are on the same team. We're all trying to get to that same place, but it's become very difficult. There are so many headwinds and adverse issues and situations that are just making it very, very difficult. Anytime I've spoken to any of you, whether it's the law firm or industry side, the number one word is I'm really busy, I'm overly stressed, and I think everyone's just having a really hard time doing their job. So that's what the goal of this is. It's just to try and get the discussion going. For the lawyers here, please, when we've had this discussion before, no whining, no crying, none of that stuff.
I'm not allowed to whine, Howard?
Say that again?
I'm not allowed to whine?
Well, no whining.
Did you say we're out of wine?
It is a no whining place.
All right, no whining.
So let's get going. The first question we're going to be talking about is, my area is kind of the relationship in the what's important to the industry and what is important to the law firms, and how are we just working together kind of on a day-to-day basis. What are the trigger points for the industry? What is causing problems? What are the law firms doing that is what exactly you want them to be doing? And I think we kind of know a lot of the basics. I don't think there's going to be too much surprise up there. I am curious to see if the law firms that are answering these questions, if there's going to be some space between the law firms are answering the questions and the way the industry people are answering the questions, but we'll see. So the first question, if we can just put it up, just so we have a breakdown of about how many people are from the law firm side or from the carrier side. If you could just indicate number 1 or number 2, please. I don't have the. No, not to. I don't know if I'm controlling the. I'm sorry.
Oh, that's it.
Yeah.
You want to vote?
No, I got a lot of stuff. Press it. Sorry, guys. No. I need help. Oh. But I didn't see the result for. 50-50 we'll call it, and that makes it easy. So we'll know when we're seeing some of these answers what the breakdown is. So am I controlling this? All right. All right, let's talk about rates. It's always curious, I think, to the law firms as to once a rate is negotiated, do the carriers care or take into account which law firm am I going to retain? Am I going to try and retain the law firm that I have a lesser rate with? Do I care or do I not care? And as long as they're on the panel and they're approved and I want to hire them, if they're on the low end or the high end, it doesn't really matter to me. So let's answer.
I think, Howard, let's explain. If you're in the industry, you'll be choosing from 1 through 3. If you are on the law firm side, you'll be choosing from 4 through 6. And then the charts will be split up in that fashion. So again, lawyers only consider 4 through 6. Industry professionals, please consider 1 through 3.
We couldn't have made it more confusing, but let's keep going.
Howard, I actually think there was a prior slide that explained that all of these questions relates to something. Am I wrong about
let's stay, we're gonna
So
stick.
Mitch, is this the type of interaction you were considering?
Yeah, this is we wanted to talk. You know, it's
I
good that
think
we
it's
examine the
confusing.
process of asking questions at a conference. Let's spend a lot of time on that.
I'll be honest, it's not what I envisioned. But
Okay.
I'm about to leave.
All right.
Let's
Vote on this one. We'll come on, vote. Let's go.
vote.
Yeah. Come on, we got a lot more of these to get through. We're bogged down on one. All right, answer? Are we going to do it? Answer question by question? Yeah. Okay.
Answer, please.
There we go. A little interesting.
So, number 2, for both the lawyers and industry, somewhat important. So, the rest of it, it's interesting, mostly consistent. I guess the lawyers feel, that it's less important than the industry people. So it's somewhat important. Maybe someone can help me with just the answer to my question. If you are assigning a case to a law firm, are you looking at the rates? Do you know what the rates are? Or at this point in the process, it just doesn't matter to you? I see some head shaking kind of in both directions.
It doesn't matter. It doesn't matter. It doesn't matter.
Gary,
One second.
we are logistically a hot mess here.
Come on, let's.
At the end of the day, it's the results that matter, and I want council to get the results. But if council's 200% of their competitors or their peer group, then I have to justify that to people who don't understand the importance of getting results. So it's naive to say it's unimportant, but the real thing that matters are they getting the job done.
And maybe a question for the room. The defense to indemnity ratio that everybody likes to talk about, the metrics that you have on your various panels, how much does that come into consideration that you decide on where to send a case if it's, let's say, a catastrophic case? And just by a show of hands, does that pass consideration of your internal analytics on a firm weigh into consideration when you have a bad case, or is it just, I don't care, I got a bad case, I'm going with the best lawyers? How much of that is controlling, if at all? No hands. So I would say it's not controlling a bit.
Gary, right?
One here?
Yes, actually, we went to a tier rating based on severity of the case, where when you get to a tier 1 case, we're not considering as much on the hourly rate because we know that this is going to be one that's going to be costing us millions of dollars, and we're not going to pay a dime less for an hourly rate when we're going to be spending the millions of dollars in settling the case eventually.
So have those tier 1 law firms that are on your tier 1 panel, have they been separately vetted to become law firms that you're most comfortable with handling higher exposure cases?
Correct, both on past experience and other vetting process that we use.
So good experience, good success, consideration for the higher exposure cases.
Correct.
Yeah, we got to keep going. Financial exposure of the matter, we just kind of got that. I'm going to pass over that one. So there are some questions coming up about the features that you like about law firms and the features that you think are important to you in hiring a law firm and the various ways that you're using them. You'll see, I'm not going to ask for votes on each of these. Early resolution. We got to vote on that. 70% of the law of the industry says that's important. That is not surprising at all. Risk transfers. Accurate evaluation.
Are we supposed to answer them, Howard?
I'm going to go through them quicker. Is there? Well, I think that
This is like
well,
speed dating with
well,
the client.
The reason I'm skipping over them is I'm guessing we can do it by a show of hands because
I think we could quickly vote and let's just see it so we all know what it says. I think we got these. We might as well use them.
Let's do it.
Should we go back one or two? All right, let's start with there. Go ahead.
Let's do this one. Risk transfer. Why don't we take a vote?
All right. Important.
Important. My premise about these questions is that fundamentally they're the basic requirements that you're asking a law firm to do. And I would be shocked. I mean, I understand there may be some subtleties and distinctions. Maybe you'll put risk transfer ahead of early case evaluation within that world. I get that. But I'm surprised that it's not even, 100% on each of these, that you are expecting a proper evaluation, early evaluation, that you're not getting a call on the eve of trial or the eve of mediation that we're changing our evaluation and increasing it. So I'm lumping these together. If we just continue again, accurate evaluation. Again, I don't know how anybody would use a law firm that is consistently not giving you accurate evaluation. I think that the vote is showing that. Here's the one. This is a death knell, right? If a law firm is changing their evaluations on the eve of trial, I would think that that's got to be the highest on the list in terms of what is causing the stress and what's causing the problems for the carriers. Why don't we do a vote? And I think it is the highest. Communication above and beyond the guidelines. We should vote on that. Again, I think that, there's a theme that we've been hearing, and I think we'll continue to hear about communications and whether it's responsiveness and just returning an email on a timely manner, satisfying all the litigation guideline deadlines and things along those times. I think the point of this question, though, is more meaningful communication above and beyond what the minimum standards that's being set by the litigation guidelines. And whether that is phone calls or roundtables or whatever we should be doing to have a much more meaningful conversation, parsing some of the facts or evaluation beyond what we can do in an email or in a report. I think to me, this is a major headwind that we're all facing, where I don't know that emails and the reports are really giving us the information that we should have to make the meaningful decisions that we're trying to make in the most appropriate way. So let's see where, Joe?
Doug Betkowski was here. He came for one night,
Hold on.
which I appreciate. But Doug is really big on pick up a phone. I mean, these, especially the young people, but I'm guilty of it too. Pick up a phone and call. I know we're all busy, but there's something to be said for not just doing everything electronically and by email. I make phone calls, and Doug would say that if he was here, so I'm speaking for him. Pick up a phone.
I'm going to get Brian involved on this subject of law firm performance, right? That's what these questions are about, and what you see from your perspective, both from the law firm side and the carrier side, about how important that is to everyone. Again, I think we're stating the obvious, but I think your perspective.
Does this work?
Yeah.
Can anybody hear me? I think what I see on the law firm side.
Can't hear you, Brian.
You can't. Is that,
You have the mic, Gary?
Sophia,
I think all you really need to know from the law firm side is, even in 2024, we're still standing around with manual systems to see if the report letters are going out timely, okay? And attorneys sitting down with associates and people like that saying, when was the last time we did a report letter in this file? The technology to manage all of that's existed for more than 10 years, but even now, it's still a major challenge for most law firms that most lawyers don't have a basic dashboard on where the status of their cases are at any given time on the firm side. They kind of have it here, and they know what's hot because they know what's coming up, but they haven't even leveraged that level of technology yet.
I'm curious about this one. I got to wrap up, but I know that almost every Themis firm, if not all the Themis firms, are trying to add value beyond just the legal services that we're providing, keeping everybody updated, providing whatever seminars or whatever we can do to help you guys out. I'm curious where this one ends up in terms of importance. Yeah, I think it's different for everybody. I think I would be surprised if the law firms don't continue to invest in this. We get good feedback when we're providing, again, meaningful, I think, updates on what is going on in each of our jurisdictions. But I think it's not for everybody in terms of maybe we're, sometimes the stuff that we're sending out is too general or not specific.
They might be inundated.
And inundated. Yeah. Joe was saying that there's too much coming into your mailboxes, and that alone is a problem. All right,
Howard, you're getting the hook.
Are there any Warner Brother fans out there where that giant hook comes out the Bugs Bunny?
I'm going to bring you up to where you are. Here we go.
Thank you.
Thank you, everybody.
We're going to try to successfully transition from Howard's section to mine. Thank you, Howard. All right, so on the technology side, is this working? Omaha, Howard. Omaha, sibling. We're working now. Excellent. Howard, here's your calculator. Here you go. Thanks. All right, thank you, everyone. Again, I'm Gary Bauman, and I'm going to transition the conversation to a topic that sort of gets a little electric for some folks: nuclear verdicts. And I want some feedback from everybody. Highlights get everyone's attention, right? Or headlines get everyone's attention, and 9-figure headlines are becoming more and more common. So, I've been asked, Gary, I asked some lawyers and I polled some friends, and I said, from the lawyers, what do you think the most important aspect to avoiding a nuclear verdict is? And all the lawyers, trial lawyers who have big egos, say, well, likability. I got to get the jury to like me. And I asked some clients, I said, what do you think is the number one thing to avoid a nuclear verdict? And they say, you got to get the jury not to like the plaintiff. And it's sort of, it's an interesting point. Both are good points. But I'll share that my personal belief is relatability of your insured, my client. Because the jury already has preconceived ideas that your client has done something wrong to cause this person to file a lawsuit in the first place. And there must be a reason. Let's hear what they have to say in response. So I would just caution focusing your direction too much in one area, either trying to make sure that they like you or make sure that they hate them. Make sure everything is relatable for your client, because in the end it comes down to credibility. And I would encourage everyone to abide by the philosophy of own what you own, admit what you should admit, concede what you should concede to get that credibility. And plant those numbers. You've heard other people talk about planting numbers. I also believe you should plant some numbers early in the case that may be reasonable, just in case they don't agree with your main argument, which is, of course, 0. So, Brian, I'm going to ask you a first question here. What is your feedback, your take right now in the industry as far as the tenor of the knee knocking from the carrier side? Is it about the same as far as the trepidation of these nuclear verdicts? Has it increased? And if so, why do you think that is?
Well, what I think is happening is, they always make the headlines, but really nuclear verdicts are not the mainstream of what most people are dealing with. So if you can sort of ring fence those and set those aside, really where I see most of the energy going in is trying to control the sort of the slope of the bell curve. It's not, you can try to manage these extremes to one extent or another, but the real expense is in the middle of the vast majority of things. So because if you throw all your resources into trying to control one nuclear verdict in Mitchell's hometown, you'll probably lose the war on, where you're getting cut to death every day on all your other cases.
Well, it's a really interesting point that you make, which is don't focus on the single event, focus on the bigger picture.
Yeah.
But do you think that these 9-figure verdicts that are being reported, that it's pulling that bell curve towards the other side?
I think it has the potential to do it, and when you start thinking about what it takes to really get one of those verdicts, the fact that you have that sort of lawsuits now, or the resolution of lawsuits are actually becoming what's called an asset class. It's an investable security at this point. So, if we ever get to the point, for example, where you're able to sort of crowdfund lawsuits, if you can think about it, okay? You'll just be completely, the whole idea of, big companies can just litigate you to death and just wear you down, and so if you're a smaller plaintiff or you've got a case, you can't match their resources, I think is going away at an exponential pace, because there are billions of dollars being pumped into funding these lawsuits now, where in the past would have gone away much earlier because nobody really had the capital to push one of these things all the way to that end. Okay, so that's a huge part of it.
Are you seeing perhaps a desensitization to large numbers by all the reporting of what professional athletes are making incredible amounts of money per game, per day? I mean, that's always been there, right? I mean,
everybody's trying to win the lottery. I don't think, I think educationally speaking, most people really don't understand, $1 billion from $1 million, from $100 million to $100 billion. They really don't. I mean, they just think, well, I'll make a point here. It should be $1 billion, and some juror is going to sit there and say, it should be $2 billion.
Yeah, and I think tying dollar values to real world experience is important when you're in a catastrophic case. Telling a jury, $350,000, we're going to pay for the college education of that child, as just a single feature for them to consider, let's say. Something tangible rather than just fighting saying, $25 million is a lot of money. Yeah. That never wins.
Not compared to $1 billion, but yeah.
Yeah, well, you're getting struck from my jury, by the way, on $1 billion. Okay, so folks, first thing we're going to have you take a poll on here is the reptile theory. We're not going to talk about it. We know what it is. So, are you concerned? Okay, again, industry folks, 1 through 3, lawyers, 1 or 4 through 6. Are you concerned about the use of the reptile tactics? Take a second and vote, and I'll show the answers. Well, it's kind of interesting. The carriers feel more strongly about it than the lawyers. Lawyers seem to think not too worried about it, maybe a little bit. Carriers more so. But let me ask the lawyers. How many lawyers are filing motions in limine on reptile tactics? Everyone? Good. Now, how many are being granted by the trial courts? Why is that, Jamie?
Because unless you can point to a specific thing, it's like, first of all, they're getting into how the plaintiffs say, well, they're trying to restrict how I practice law, my work product. Like, I'm not going to violate any golden rule or anything, but they can't point to a specific thing. That's the problem. If the judge had a specific thing, I don't want him to mention this specific word or something, then that's something they can grant, but the motions are too general that we're filing, I think.
Yeah.
But I think it's important to still do it.
Hold on, the mic's coming here for everybody.
It makes the plaintiff's attorney commit to, I'm not going to violate any of these rules. I'm not going to do that. And it also educates the judge. And I've watered it down to the point where I put as a short thing and I say, Judge, I want to talk about this. I want this to be something that, we have other cases where this has been done. We need to have this as an issue. And sometimes the court's like, well, what are you asking for? Well, I just want the court to be on notice of these issues. And then the plaintiff's attorney will say, I'm not going to do that. I'm not going to go this. I'm not going to do that. And I think at least you've set up the argument for when it does happen. See, Judge, this is what we're talking about. We knew this was going to happen. We brought it up before. He said he wasn't going to do it. And now it's just a twist on the golden rule or whatever. So I've never had them granted either, but I feel like it sets the stage at least.
I think you're 100% right, Eric. And the other thing is, it does set a tone for your objections, but perhaps more importantly, it's going to sort of hold him to the curb during voir dire when they start to plant those seeds. So it's nice to see that we're all in agreement that little hope of him being granted. The judge is going to say, as Jimmy said, well, I'll take it on a question-by-question basis. You can object when you think there's something wrong. But it's important we keep it all on our radars. All right, second thing. We're talking about, let's see, plaintiff firms now referring to their high exposure cases to better trial attorneys. The M&M firm, of course, famously is hiring defense lawyers. You know, guys that have been in our shoes for 20 years who've tried a bunch of cases, paying them double to come in and just try cases. You don't have to work cases, just try cases. And they're good trial lawyers. They've tried cases their whole life. Are you guys concerned about this? It's not new, but it has been going on. Again, it doesn't look like the defense lawyers are too worried about it as much as perhaps the clients. Brian, what do you think about this practice? You're aware of this approach where the large plaintiff firms are hiring defense lawyers or hiring experienced trial lawyers, and they're pushing everything to trial now.
Yeah.
Are you seeing more cases tried on an annual basis going forward versus a historical perspective?
I don't think so. I think they'll push certain ones, but I don't think that you're seeing it. Just if you can stop and you take, say, lawyers from, I don't know, 55 and older versus people under 55, and I don't know if that's a bright line, the trial experience is all overwhelmingly concentrated at the top. So I don't think the future, this is just no one knows the future, but from my perspective, I don't think the future is that we're going to try more cases. I think we're going to sort of game it out.
Well, I agree. I think we're the way of the dinosaur. Trial lawyers.
You just won't be here anymore.
Well, then that's just it.
Same thing, right?
Now, like many of my colleagues in this room, I was trying cases as a young lawyer, and I proved my worth. And boy, I was a second, third-year lawyer, and I was trying cases. By a show of hands, how many clients would let a 5-year associate first chair trial? 0, right? 1? Volvo? Yeah? Over here. Mitch? 5-year associate? All right.
Absolutely, because if I don't, then when that
Hold on. Howard, can you give her the...
When that 5-year is 10-year, they haven't tried a case, right? You have to, we as an industry have to let them try cases. I'm not going to give a 5-year who's never tried a case before a multi, $10, $100 million, $1 billion potential, but you got to let them try the cases. And I get why at carriers, if you take a verdict, everything gets questioned. All of your decisions are Monday morning quarterbacks. Everything is looked at under a microscope, but the part, and from the carrier perspective, is communication. You have to tell the person who you'll be reporting to, whether it's in underwriting or whether it's in claims, this is a 5-year associate who has had great experience up to this date, is being supervised by a managing partner. We have to let them try the case. You have to put that out there before the verdict, because after the verdict, it sounds like an excuse. But if we don't let them do it, we're screwed as an industry.
Melissa will love to talk to you about next gen and those young lawyers trying those cases.
Yeah.
Absolutely. Paul, did you have your hand up too?
Yeah, I just want to echo what Krista said. We also have a philosophy that if it's not a potential nuclear verdict case, that we want the associate to get some experience as long as they're being overseen by one of the partners.
Yeah, you don't jump into the first chair, obviously. There's a couple of second chair rides, but it's nice to hear that we have a thought process where we know we have to train these young lawyers.
What about what about the second chair situation?
There's a question, are you going to pay for the second chair, right? And I have some clients who say yes. I've had some clients say no. And I have paid, out of my own cost for that lawyer to go with me to trial. For 2 reasons. Selfishly, I need someone in my ear reminding me of all the facts that they've worked up on the case. But also, I need selfishly, again, to train that young lawyer for succession of my law firm. Because otherwise, we're going to run out of trial lawyers, as we get older here. So, Brian, do you have something you want to add?
Yeah, I think
well, Michael, yeah.
Question. While I can appreciate the necessity for bringing young lawyers along and whatnot, I think you're missing an opportunity to find a business case for the case itself on how that associate might benefit, how it may play into the jury or might play into a witness. It's not just for the benefit of a firm developing their lawyers or an industry, looking for that succession planning for the next year's trial lawyers. And I think there's a lot of value when you think about the type of jurors that you may get. And you talk about the earlier conversations that we had today about nobody wants to listen to somebody that's north of 50, right? And when will somebody...
I'll see you now, then I'll be leaving.
So I think Michael has a point as one of the younger lawyers in the room.
Yeah.
I mean, the first few cases I tried were I was in my 20s and I was with a 60-year-old guy, and I would have jurors come up to you and they say, we really like that he let you be an equal. He let you stand up, he let you talk, you got to be heard, and it said something about your client's character that they trusted you just as much as they trusted the 60-year-old guy. So Michael, I think there's a point for the case. It adds value. Your jury is not just 60-year-old professional men, it's everybody. And they like to see the younger woman, the person of color, the person who may be differently abled in a courtroom having a voice just like them.
Well said, excellent point.
I 100% agree with Melissa on that. The other thing is, a very easy role for your associate is they're the person being the scribe of everything that happens during that trial. If you have a week-long or a 2-week-long trial when we're trying the catastrophic cases, we don't remember everything the witness said like 6 days earlier when, I'm crossing that person. But you want to have somebody that knows all of those little things the witness says so you can bring that up in closing. It is a very easy business case, like Michael said, of I need my associate there to take down every single detail that witness says, because you physically can't do it if you're crossing them, and then you use that to build your closing. It's a very easy way to make the business case to someone like Michael, who I'll give credit to, just let me take a second-year associate with me to trial, and it wasn't an issue at all. But that was the person that was there editing the motion I was going to file while we were sitting in trial based on what the witness said.
Okay. All right, this is the last one we're going to vote on here. We all know that relationships are just critical for the success of our industry. As we had some earlier conversations with some clients, unfortunately, the decision for some of the financials may not be within the control of everyone in this room. It may be by another, section of the carrier group who talks about the auditing, or who talks about what we're going to pay for, whether it's the second lawyer at trial, things like that. So this next question talks about if I recommend to do something like a mock trial or a shadow trial and it's refused because it's going to cost too much, or if I'm in the excess layer and I make the recommendation and the primary carrier who's funding the defense doesn't want to do it, how does that play into this here? Really important stuff. And I think that goes to some of the frustration that I talked about that we equally share sometimes. Sometimes the companies won't allow it for whatever reason. You want us to bring a second lawyer, but you can't authorize it because the company or whatever. It's that whole second division, Brian, of how this is divided up. And what are your thoughts about how can we approach this? How can we make this a better process?
Specifically, convincing the carriers to let you do some of this stuff?
Well, some of the guidelines, perhaps, what I'm talking about.
Well, adjusting the guidelines. Sure, I think we're getting, we're talking about AI and some of that stuff. I think we're getting to a point of accountability eventually where actually the net result of it, the indemnity part of it, is actually reconciled with what the cost to defend it was. Mm-hmm. And right now, because that sort of record, from start to finish, from the first notice all the way through the resolution, is not complete. It's more anecdotal. So I think it's going to get down to ROI. It's like, okay, we'll throw everything you want at this case, okay? But we're going to be looking at the ROI when it's done.
And maybe the easy solution is, as Paul said, you tier these cases. Tier 3, you have these sort of governors in place. Tier 2 that are a little less. Tier 1, gloves are off, something like that.
I mean, some of it's just pay it. It's not worth, you know, you might get we might spend a whole lot of money and we might get a 2%, 5%, no one ever's really going to know, better result. And so what if we just paid and got rid of it? I think there's a lot of that.
Thank you, and thank you, everyone. I'm going to pass the baton now to Mitchell, and he's going to talk about some of the guidelines.
I'm actually going to give the baton to you.
Oh.
So we're going to spend a little bit examining the effectiveness of the guidelines that most of the industry guides their attorneys in the practice of their handling their cases. So let's go to the first question. Do you think that guidelines are ineffective, somewhat effective at lowering legal expense? Okay. That's interesting. So, so it's interesting that the industry thinks that it's pretty ineffective at lowering legal expense. That's interesting. And the lawyers are in the middle. Anybody want to comment on that? And comment on that? There you go. Tony? Tony, here's a...
So the people who are demanding the guidelines and have been sold as bill of goods are not the people who are actually hiring the lawyers or monitoring it. And I think that, you know, they make these effective cases at very senior layers of companies, and nobody agrees with it because it's, you know, hourly rate is insignificant, and it's all about outcomes and what is the total billing associated with the success of that outcome. And nobody's been able to manage that. As an intermediary, I can tell you that all I hear is complaints on both sides about, I can't get my bills paid. They want, you know, these guidelines require an extra 5% so I can get paid in 30 days. All these like rules and regulations, you've got ineffectiveness and discord through the whole process. And the people who have to implement it are frustrated with the fact that they know they can't get the best attorney for the case because the hourly rates are suppressed.
Any comments on that? Okay. Here we go.
You know, I know it's frustrating for counsel dealing with the billing guidelines and all of that. It's equally frustrating on the carrier side, in my opinion. And here's why. I'm not in your firm. I'm not doing the work. And the people that put the guidelines in place aren't either. And so we get the pressure from up above to keep our expenses down and whatever. But it takes a lot of work on our side to review all of that and check all those administrative boxes, which in the end takes away from me evaluating a case, getting it ready for mediation, returning your calls and your emails. So it's just as frustrating as a claims handler to have to deal with this as well. It is what it is. It's the rules, right? But just from a carrier standpoint, I feel your frustrations as well.
Well, and it's the conundrum we all go through. We can pay less legal and a lot more indemnity, or we can pay less indemnity or a lot more legal. It constantly goes back and forth and back and forth.
But I have a question. That's an important part of this.
Well, that's actually the next question, which is, do you think it's effective at lowering indemnity payments?
Yeah, that's what and what do you base that on? That's what I'm really.
Let's vote on this one. No, I don't have a voter.
Didn't work?
No, I don't have this. I don't have the. I'm sorry, what?
The guidelines are effective? Is that the question?
Yeah, are the guidelines effective at lowering indemnity payments? Well, look at the industry side, ineffective, and the lawyer side. Okay. Yes.
So As the
Krista.
girl who said she loves her job, when I was a claim rep, the worst part of the job was the bill review because it set you at odds with your partner that you're trying to build a relationship with, right? I, as a claim rep, want to build a relationship with my attorney, and now all of a sudden I'm going to say things like, give me 5% back because I pay you in a timely manner. The electric company doesn't do that for me. The water bill doesn't work that way. Why are we asking our attorneys to do that? It's really, truly obnoxious. It's one of those things that we, at some point as an industry, we're pushing all these limits and getting away with it. And I think that most claim people, if they're really dedicated to their jobs, would agree with me that doing this not only is just a terrible task, but also it does not feel good to us either. The issue we have, though, is it's not like the old days where my husband, who works at a defense firm, his senior partner said he used to submit a bill to the carrier that said September for services rendered, $40,000, and he got a check a week later.
Yeah.
Like, where's the difference between for services rendered and the monotony that you guys have to deal with of the 6 minutes at a time? There has to be a breaking point there, and I think we as an industry have to be open to piloting different ways to look at this, to encourage the young people to be able to sit second chair and not lose all those billable hours, right? To encourage us getting paid for the right amount of work. But to me, a lot of what you've been talking about today, it goes to the total cost of the claim. I would rather, if I have $1 million, I'd rather put it in your pocket than Morgan & Morgan's. If I'm paying $1 million either way, I'd rather give it to you guys. So, I mean, that's the way we need to look at it. But the problem is, as much as I've been talking about this and thinking about this, I don't have the answer either.
Well, let me ask you a question, Krista. So, because I've thought about it a lot too, and you don't move the Titanic around quickly,
True.
right? You got it, and you're dealing with a lot of people on the other side of the house, that are worried about their costs and they're worried about what's being paid to lawyers. But to me, and what I'm going to try to get to here is that maybe a slight adjustment in the guidelines to allow collaboration between a young attorney and a senior person who's trying the case, and let them see what's going on in the case, and allowing two partners on a case if it's a big case and deserving of it, and not have to, sure, I know what you guys will say, well, just call me. If you call me and ask me, I'll approve whatever you want to do. Well, we don't want to do that on every single issue that we have. And so it becomes, so if we just look at some of the guidelines that are preventing us from doing what we're doing and what we all want to do, and we all want to trust each other. That's why we're here. This is about creating relationships that are about trust. And if you don't trust me, don't hire me.
Yeah.
George.
My colleagues over here, both of them apply to mine. Both said the same thing about you. The guidelines are for the users, not for the ones that you're doing.
And you know what? You use those same guidelines on the cases that you worry about the most. And for the attorneys that you care about the most, you're using those same exact guidelines as you're using for the small automobile case as you're using for the catastrophic case. Doesn't make sense.
Mitch, so I can't prove that because I hired you, I got a better outcome on that case. Just can't do it.
Who's talking? Okay, sorry.
See, that's the problem. You can't prove the negative. And I know that I got a better outcome because I used you or Lisa. And you know it, but the only way you can prove that stuff is over time. And over time, there's so many variables that any indemnity swing can be pointed to. So that's always our challenge.
But aren't you making that decision when you select an attorney?
Oh, yeah.
Well, before you select that attorney, aren't you making that decision that I trust this attorney and I know this attorney has my back?
Yeah, no. I guess the point is, I'm hiring attorneys to get the outcome, and I've always been a proponent of spending money to save money. And within the industry, my industry, it's almost everything is stacked against that. Because I just can't prove that by hiring better counsel, I got better outcomes. It's almost impossible to prove that. Whereas the next guy up who's competing for my role, if he shows I saved 5% on our legal spend, hey, guess what? That you can prove every single day month over month, year over year.
But are you also analyzing the indemnity payments that
Yeah,
comes as a
but- okay,
result
so-
of losing that 5%?
But what he will sit there and say is, yeah, indemnity spike, but what else happened? And there's any number of variables that could go into explaining an indemnity spike when you've lowered your counsel spend. And so he's not going to say, hey, that indemnity spikes because we spent more on
You wanna
counsel. He's going to
comment
say
on that?
it's because of nuclear verdicts. He's going to say it's because of social inflation. It's going to be Trump was elected president. It's going to be a pandemic. Anything like that. But I can prove legal spend decreases, and that's a problem for you. It's a problem for me. It's a problem for our carriers. And that's what we're fighting against. And the good news about this is, at least in this transportation space, we realize that with the severity we have, it's not as big an issue for us. But you get outside transportation where you're in just commercial auto or lower policies, it's all about controlling costs. And that's what we're up against. And in a bigger carrier, I'm competing against someone else who, you guys are always going to be our single biggest cost when we're trying to figure in what our costs are. And we're always judged by our combined ratio. And controlling costs is unfortunately the roadmap to success for most carriers.
The question I obviously would have is, can you prove that if you spend less money that you save more money in the end? And I would argue the opposite. I'm sorry. Go ahead.
I think I had a question before I was unceremoniously pulled off the stage. What data is being collected by the carriers in order to make these evaluations that Pete is talking about? I mean, we're told over and over again that part of the reason that our bills go through these billing programs is to gather data, right? It's not just to reduce our bills and make sure that we're complying with the guidelines. And it's always been a bit of a mystery what is actually being looked at and what data is there, or is it mostly anecdotal, and what is going on? I'm curious from industry people if there is some consistency going on within the carriers, if it's very different. I'd love some feedback on that.
It's the flavor of the month. I can tell you from working with 5 carriers in my career, and the one that I'm with now, I've been with for 8 years, uses a third-party vendor to review the bills. And we don't look at really how much the cost is as much on the defense side. We look at how much is the attorney appealed on things that they put on there. And what I do to prevent that is I teach our adjusters, when you're going to authorize so many hours for this or that, and we don't put a lot on that. Wait a minute. When they ask for the amount of hours, I make sure that I tell them to, when you put it on your bill, indicate that it was already approved by me, and it stops the appeal. So we're getting through the process that way. But depending on who the carrier is, I've seen carriers do multiple different things on how they deal with defense counsel bills. But I also saw in the last couple of years from this one client that we have that has a huge SIR, is that they deduct right off the bill. They have counsel deduct 10% off the bill. And depending on the success of the case, they either negotiate that 10% back at the end of the case, or they just give it back to them at the end of the case if they consider it a win. So that's another that I have not seen in the past, and that's done by the client, not by us, the insurance carrier.
Okay, so we running out of time?
Yeah.
All right.
Yeah.
Let me quickly go through some of the questions so you see where we're headed. Are the guidelines good at creating efficiency and making sure that the tasks are going to the least expensive person? Is it good at promoting early resolution? Do the guidelines help you promote early resolution? Yes or no? How many say yes? Okay, there's the answer there. Oh, look, we had a vote on that. Okay. Creating a positive working relationship with the carrier and the law firm. Yeah, I think we know the answer to that one. Ooh, someone said it's effective. A lot of people said it's effective. Allowing inexperienced attorneys. Okay, we talked about this. The old collaboration issue. Developing unique tactics, litigation tactics through discussion. How often, when I was a young attorney, we'd get in a room and we'd talk to some of the folks, okay, let's brainstorm. Let's figure out, we got this unique issue. What are we going to do? Well, we're not allowed to do that. We're not getting paid for it anyway.
Just get up there. Should I? Just.
Developing a relationship between the attorney and the claim professionals. That's about, the time that it takes when you're on the phone with somebody and you develop that relationship that I developed with Tammy some 25 years ago or so. But we developed that kind of relationship that people aren't developing anymore because now it's all emails. The associate doesn't want to waste time talking to somebody to get away from his billables. So we're not creating that trust and that relationship. Thankfully, we have things like this. Sorry, Gare, I know I'm getting the hook.
Howard has asked me to make sure he's not the only one that got the hook today. So.
Okay, you guys can go. I'll just stay here and I'll keep talking. I want to get through
Extra
this stuff.
credit.
Well, real quick, but another thing, and we don't even have to go through it if you don't want, but it's about who makes the decisions, right? Did the guidelines allow to, who makes, that comes later. This is some of the guidelines and what you're allowed to do. Let me get to one part.
That's why I think cutting all off the slides off.
Are guidelines reviewed and adjusted? When's the last time your guidelines were looked at by somebody and said, you know what, we need to change this? Guarantee it hasn't been done in a long time. Do you apply different set of guidelines for the simplest case or the highest case? Okay, here, this is what I just want to, who makes the decisions? Is it claims? Is it vendor management? Or is it a joint decision? We're not going to vote, but those decisions that, who do we add to panel counsel? What's our trial strategy? Does anybody want to give some input as to who makes those decisions in your company? Anybody want to voice that? Nobody wants, do we have somebody now? Okay, then we'll call it a day. Okay, so any questions, any comments? Everybody wants to go. Okay, there you go. Mike.
Just let me throw this out there. Don't know where it might go.
Uh-oh.
Take a look at the guidelines, and you write them.
You know what? I'll accept that challenge.
And see how, from your perspective, you can present guidelines that may be able to work on our end of the equation. I'd like to have that.
I, on behalf of the Themis attorneys here, will accept that challenge, and we're going to develop guidelines for large losses and excess claims, because that's what we think really should be looked at first. Okay? So we'll all do that, and then we'll get your input, and maybe we'll really make some change here. Okay? Themis is going to make some great change. Okay? All right, but before we make that change, we're going to have lunch. And then we're going to talk to Judge Newman. Hopefully you all got a chance to meet him. He was in the Murtaugh case, and he's a great guy and fun to talk to. And he's going to be our keynote speaker. And then we'll have some fun. All right? Thank you all.